is here for our rental property managers, owners training for specifically for the Housing Choice Voucher Program. So if you're not here for that, you're in the wrong room, but I'm pretty sure you're all here for that. It's been a while since the Housing Authority has held a workshop like this, probably pre-COVID. And I will let y'all know that our agency is going through some changes. You'll see that I'm a new person that probably you've never seen or known or talked to before, because I just came to the city during the COVID years or at the end of COVID. My name is Leilani Hines. I'm the Director for Housing and Neighborhood Services. I have over 30 plus years in the housing industry, working in the cities of Chula Vista and Carlsbad prior to coming here to Oceanside. But I was the first of many changes that have occurred in the Housing Authority. I think if y'all have been around long enough, you know that we experienced a huge shift in leadership and a huge shift in what we call a little bit of a brain drain. We had folks in our agency who were probably with the agency probably 30 plus years as well. So it's, I would like to say, a new agency because we're getting a lot of newer staff. Many of the staff are new, and new laws are coming, new things are changing. The environment is all new. So it really is a great time for us. If you also have not heard or known, the department as well, the Housing Authority, is going through what we call an organizational assessment by the city. It's the right time because we've got new leadership, we've got a new team, new laws, new programs for us to do a self-reflection of who we are and what we should be doing and how to better serve the community. And that's a little bit about why we're here with you today, to explain some of the things that are going on. You are going to see changes. You're just going to see it from our department. That's inevitable. It's hard. And that's why we're here, is to talk through those and to build that relationship with you all so that we can work together to provide a really critical service to our community. It's needed now more than ever. Y'all know what the rental market is out there. You know of pending changes that are hitting our vulnerable population groups out there in the community. So this partnership that we have and how we work together and provide a good program that meets both our needs and your needs is really essential. It's essential to the success of the Housing Choice Voucher Program. So I want to thank each and every one of you for being here today. I'm just going to do the introductions. I wanted to have our staff introduce themselves as well to you so that you know, because most of our work goes by really snail mail, emails, and telephone calls. So I wanted you to meet the staff that is involved in the program so you know who they are, but also keep in mind, I said change is inevitable. We are contracting on our supply. We might be hiring new people. So who might be your housing specialist today and that you're dealing with may change. So I'm going to start with Ray Rule, who is our new housing program manager. He takes over the role of Angie Hannafin. If y'all have been here long enough, you remember Angie. This is Ray Rule, and he oversees the Housing Choice Voucher Program. Myrna Arevalo is not here today. She's taking over the role, if you remember, Kisa in the back, who is now retired but helps us out on occasion, like for today, because she's the one who's done this in the past for us. But Myrna's taking over her position. But Myrna's been with the agency for a very long time. So we have stability there with Myrna. And then I'm going to start in the back with some of our housing specialists. And I'll start with LD. If you could give your name and just... And LD's been with us for a while as well. So a lot of great institutional knowledge in the program and in the city of Oceanside. And then the rest of the team is practically new that I don't think y'all have met since before COVID. So Rigo will just go down the line. And I think that's it. Is Ebony here? Okay. And so we have Ebony Hunt, who will be on the agenda a little bit later. She's the person that you deal with when it comes to all things payment and financing. So she's the direct contact for that, and we'll answer all your questions related to that as well. And then some of you know Susanna Sandoval. She's been with the agency for a while as well. She is dedicated to the housing inspection. She's probably the person you see most often because she's in and out of your property. So you physically see her more than you will our housing specialist. But just wanted to give you an introduction to the staff and note that many of them really are new as most of them came on around the same time I did or just before. So all new staff, hopefully a newer and improved agency. Bear with us as we start to make those improvements with you all. Just for some housekeeping, the agenda is there. We provided you with a slip. If you didn't get that slip of paper, there will be a question and answer period on a couple of opportunities for that. We gave an opportunity for you to put answer or questions on slip of paper that we have up here, but we will take questions from the audience. I will also say, as I said, we are going through a department organizational assessment. So if you have, it's not just questions, but if you have feedback about our processes, what we could do better, what you would like to see, please send those to us, and you can contact us through the Section 8 housing email. But feel free to do that. We would appreciate those comments, those questions, the feedback, so that we can grow and improve our services. So it'll go pretty quickly. Our goal is to get you out of here as quick as we can, but provide you all the relevant information that you need to do your job. We're going to talk in more generalities. Some of you may have very specific questions regarding a specific tenant, certain circumstances. If they're really specific, we would ask that you hold off on those questions, that maybe you talk with us individually or one-on-one, and we can work through those just in order to be respectful of everyone's time here and trying to get folks the information they need in the quickest time that we can get it to you. Oh, rent control update. So August 1, if you are subject to 1482, the new state law, or not new, it's been around for a few years. August 1st, rent increases are 8.8% for the upcoming year. Some of you may not be subject to rent control, just depends on whether or not you meet one of those exemptions or not. But that is effective August 1. So on Friday, it's 8.8%. It's a little bit of an increase from last year at 8.6%. Some of you also may know or have heard, and I'm going to announce it now because we're doing our roadshow now, or having discussions about it. In April of this year, the City Council entertained an idea about tenant protections. It is a play off of 1482, and are considering going a little bit above and beyond what state law is requiring. We are moving forward. It is tentatively scheduled for Wednesday, September 3rd, to do a first reading of an ordinance to strengthen tenant protections in the city of Oceanside. I will say that it is patterned after other cities, like the city of Imperial Beach, like the city of Chula Vista. San Diego has a much more robust program, but we've patterned it after the smaller cities. So that is likely to come forward for consideration to council on September 3rd. Two other things that council also directed staff to look into. I'm not always a fan of being the first out there, but in the city, in the county of San Diego, we do not have rent stabilization or rent control from a local perspective, like city of Santa Monica, city of LA. City council did direct staff to look at rent stabilization specific to Oceanside. We do have rent stabilization for our manufactured home communities, so it would be very similar to that, but we've been directed to look into that and to present a framework to council. We anticipate that that would go forward the same date on September 3rd. The other directive that they gave city staff was to look into eviction prevention types of programs, kind of like the city of San Diego, who has an eviction prevention program for legal services or right to counsel. So that's typically how you hear that program talked about, is either eviction prevention or a right to counsel. So we were directed to also provide them some options and recommendations related to right to counsel. So there's three big things that really affect this group right here. So keep on our radar, look for that coming September 3rd. I understand that Deputy Mayor Joyce and Council Member Figueroa are also holding a community forum or meeting related to these items on August 7th, I believe. So those are some opportunities there. Just keep aware, keep abreast of what's happening in the city of Oceanside as it does directly impact you all. So with that, I think I will hand it over. Yes. The council meeting is always on Zoom. This meeting today is on Zoom. We intend to post this on our website along with all the questions that are asked and answered today and the ones that we may not get to today, depending on time. We'll post those on the website so those are available to you. But when it's on Zoom, it does not allow for interaction. So we don't open it up on council meetings to questions from the Zoom. It's only for viewing purposes only. So I strongly encourage you, if you have a stake or have some opinion and feedback related to these topics, that you do participate in that council meeting. The April meeting was a very long meeting and there were a lot of comments on both sides of the table. So question again? Honestly, I do not. I'm going to, if you have signed up for some updates or you have your email, talk to me afterwards and I can provide you that information. I was just made aware of that yesterday. Sure. So the first question that was asked is the city council meeting on September 3rd, would it be available on Zoom? All city council meetings are available. It's on Zoom. You can watch it on KOCT as well, live stream it, but it is for viewing only. If you really want to give some feedback, be here in the council chambers, talk with your council members, send them information, letters, correspondence, etc. That's another way to participate in those council meetings. This meeting as well is in Zoom. The question that was also asked is there is a publicized community meeting that we're aware of that is sponsored by Deputy Mayor Joyce. So it is August 7th from 6 p.m. to 7:30 p.m., sponsored by Deputy Mayor Joyce, Councilmember Figueroa. It's a community meeting to talk about what we're bringing forward on September 3rd related to tenant protections, rent stabilization, and possible eviction protection programs. It will be held in the Civic Center Community Room here, 330 North Coast Highway. So the community room's right adjacent to the city library. Right. So with that, I think I will hand it over for the nitty gritty and going into the program itself to Ray Rule.
Morning, everybody. Show of hands, how many property owners are participating in our Section 8 Housing Choice Voucher Program? Okay. This next presentation is going to be about those folks that are participating, that are renting to our Housing Choice Voucher participants. Thank you for working with us as we house these low-income households. So just as an overview, the federal rental Section 8, now it's called the Housing Choice Voucher Program, is a federal rental assistance program that provides housing assistance to very low income families, the elderly and the disabled, to provide decent, safe, and sanitary housing. it's an income-based program. So, our crack staff behind you that introduced themselves earlier are the folks that are calculating what the tenant portions are, what the HAP amounts are going to be that you get on a monthly basis. On the side of the slide is some of the various programs that our housing authority administers. We have the Housing Choice Voucher Program. We also have some special purpose vouchers for non-elderly disabled households, veterans that are experiencing homelessness, families that are reuniting with their children. And we also have emergency housing vouchers for those folks that were homeless or at risk of homelessness. And in addition, we have a family self-sufficiency program that's open to our participating HCV members, folks that are working and trying to become self-sustainable, and in that they receive a payment on a monthly basis to build their assets and their income to perhaps purchase a home, start a business, or further their education. This slide is a profile of the folks that we work with. We have about 1,450 participants. A little under half of them have been on the program for about 10 or more years. The average income is about $26,000. 64% of the participants, their source of income is SSI, Social Security, or a pension. 46% of our participants are elderly households, and 48% are also disabled. So we're going to go over the new rent increase policy that we instituted earlier this month. And one of the things that we're trying to do is we're trying to be consistent with our process, streamline our process. We have about 1,450 participants. We have a small but mighty staff. So what we're trying to do is we're trying to just make everything more manageable, send it a certain way so we can address everyone's issues and get everything updated when necessary. So this is a summary of the rent increase policy. Effective July 1st, owners, property management representatives have to adhere to the new rent increase policy. Prior to July 1st, we would just get the rent increase notice. And it could come in a bar napkin, it can come handwritten, typewritten, teletype. But what we're trying to do is we're trying to standardize it so we can get more information on the front end. So we have a rent increase application that also must be completed, submitted. You must submit the rent application at least 60 days prior to the effective date and by the 10th of the month. I have a slide that later in the presentation that shows some of the dates that you guys can utilize. And as I said, we're trying to standardize how we receive rent increases. So best course of action is sending it by email, dropping it off at OHA or by mail. Please use the Section 8 at oceansideca.org email address. That's going to be our main funnel to get these rent increase applications. So this is just a summary of what I described. What is a complete rent increase application? The rent increase request form, the landlord-tenant increase self-certification, a copy of the written notice of rent increase, and the submission deadline. Postmark. Oh, if by mail, if it's mail, yeah, we'll follow with postmark.
But that's where the receiving it by the 10th of the month becomes the critical issue. So just to go back on the, no, you don't, but so I think Ray's going to go into this a little bit about, the receipt and some of the issues that we've been seeing. And I'll go back to the Section 8 email. Really important. Because one of the problems or issues that we get is that we get rent increase notices sent to multiple people. Do not send them to multiple people. It's really difficult for us to track what is the most recent, who received what, did someone attempt to answer it or respond to it or not. So we are funneling all of our correspondence to the Section 8 email. And also, as we talked about, our staff is small. We are going through changes in staffing. So today it might be LD. Tomorrow it might be Ashley. So if you're sending things to different people like that, it may not end up where it needs to. So strongly encourage you, this is that part of standardizing things, is in order for us to all be effective and to process things as quickly as we can or in a timely manner, we ask that all correspondence related to the program go to the Section 8 email address. Yes.
Know who that person is, will just pop up on some general email address?
No, actually, if you look on our website under documents and forms, there's a form or a handout that's who's my Section 8, who's my Section 8 housing specialist. So we do have the caseload assignments up on the website, but again, those could change frequently. And so you need to, that's probably a tip as well. Utilize the website to pull down your forms. Don't recopy old forms that you might have in a file drawer. We are changing our program constantly. We're kind of, right now, our attitude is more of, let's try this, let's get this out because it's better than what we had before. But as we hear comments from you all, as we see issues that are coming up, we're changing things. So please look at our website, and Ray will go over that as well for the most up-to-date forms. Sorry, Ray.
We'll get to that part. Yes. We'll get to that in the okay. Good stuff. All right. So this is an example of the rent increase request form. It's 3 pages. Participant, and I don't know if everyone got a handout, but it is on our website. And this PowerPoint presentation will also be on our website when this presentation concludes. It goes over you just have to include the participant's name, the address, the landlord's name, and on page 2 is where you include the current rate, the current rent, the date of the last increase, the requested rent, and also the effective date of the rent. You also include the unit description, bedroom and bathroom size. On the utilities section, this is a section where you can notify us if the utilities or the utility responsibilities have changed, because that is a factor in how we calculate tenant portion and HAP. If there is no change, you can just select no, and then you move on to the next section. The next section is affordable housing. There's certain rules that we need to follow when it comes to affordable housing. If your unit falls within that umbrella, please select which one applies. And then page 3 on the left side is the acknowledgement that what you're providing is, something that you're aware of. and you just sign it and submit. The form on the right is a landlord self-certification. And this is where you're certifying that you're submitting the rent increase notice and the rent increase application, and it's compliant with all federal, state, and local laws. There's also a section there for the Tenant Protection Act. There are certain landlords that are exempt from the rent increase requirements under Tenant Protection Act, and you're just self-certifying whether you fit into that category. Just so you know, we're going to have a Q&A period after this, so jot down your questions if you have any. The third component of the rent increase submission is a proper rent increase notice. So I provided the 6 elements that need to be part of a rent increase notice. There's also a sample that is available on our website if you want to use that. The rent increase notice must be in writing, must provide the date that you gave the notice to the tenant, an effective date of the rent increase, beginning with the first of the month, addressed to the tenant and not to the Oceanside Housing Authority. And it also includes the tenant's full address. And on the rent increase notice, there has to be one requested rent amount. No multiple rent. I know this is a sticking point for some management companies and landlords, but a proper rent increase notice for our purposes does not include options. So we need one requested rent amount, and it has to be signed by the owner or the agent. A signed lease is not considered a rent increase for us. It presupposes that it's an approvable rent, so we're not going to accept leases executed by both the management company and the tenant as a proper rent increase notice. And the reason why we can't do that is the housing authority has to do a rent reasonableness analysis of the proposed rent. It's a requirement from HUD, and it's something that our housing specialists do here in the office. And the requested contract rent is compared to rents being charged for unassisted non-Section 8 HCV rents within a 1-mile radius. If the requested rent is at or below the comparable rent, the rent is approved. If it's not, we would have to deny the rent increase. Other reasons why we would deny the rent increase is an incomplete application, which I'll get into about substantial compliance on that. Not a proper rent notice. And like I mentioned, it does not meet the rent reasonableness standard. Okay, so this is the rent increase application submission deadlines. We sort of gave you a pretty nice breakdown of what we talk about, because it's sort of hard to verbalize what 60 days prior to the effective day by the 10th of the preceding month means. It's pretty much an 80-day advance notice for our purposes. One of the reasons why we built that in is there's a lot of paperwork that comes in. And we want to make sure that we don't do a straight denial if we're missing a form. You know, if you submitted a proper rent increase notice to us via email and you didn't include the landlord self-certification or a part of the rent increase application, you know, that's when we would correspond and communicate with you saying, hey, you know, there are certain items that still need to be completed in order to have a fully complete rent increase application. We're going to give you 10 business days to correct that so we can properly process it on the effective date that you're proposing. So this is a good guide for deadline based on the effective date of the rent. Submitting a rent increase application. So confirmation of receipt. The only ways that we could provide confirmation of receipt is if you email it, section8@oceansideca.org, or you drop it off at our office during lobby hours. Just so you know, our office is open Monday through Thursday from 9 a.m. to 4 p.m. We're closed to the public on Friday. You can also mail it, but you're not going to get a confirmation of receipt. And that is the address. So as Leilani mentioned, we have a website. We're trying to update it daily to make it more user-friendly. All the information that we're talking about here is available on the website: caseload assignments, forms, utility allowances, and things like that. And it's on our website. Our website address is on the slide. And if you have any questions about anything really, rent increase applications, accounting questions, things like that, our 2 email addresses are here. And that concludes the presentation on the rent increase application form. Does anyone have any questions? Sure.
No, I just. I didn't get one packet.
I have a.
Provided a written copy of the rent application. As Ray stated, we're doing everything we can to update our website and to drive people to the website. So if you go to oceansidehcv.com, straight to just housing choice voucher. Click on the landlord button, or even even on our front landing page for HCV. On the sidebar, you will see a quick link to documents and forms. All the documents and forms are all loaded up on that website. There's a particular folder for landlords. There's a particular folder for tenants. And so if you didn't get one here today, you can go into that website and pick it up. Even if you go on the landlord page, there is a tab that talks about rent increase and the process. It's all in that website, and then you can download the written version as well.
Just hope you could provide some clarification on the wording, the owner agent acknowledgement and signature form, specifically at the bottom of the page. That the rent for this unit may be at any time if that finds that the rent charged by the owner exceeds rents charged for other comparable unassisted units. What does the process look like and how that works?
Sure. We haven't done it in a while, and I don't foresee us doing it. It's just language that we include, knowing that with some of the financial constraints various housing authorities are feeling across the country, we do have that as an option. It's sort of like the nuclear option, reducing the rents to make it in line with what the market is forecasting or is current. But at this point, that's not something that we're advised to do by the federal government yet.
So I will say for the program, so y'all have been seeing all of the news related to federal budget accountability, transparency, et cetera. The rent reasonableness regulation is the cornerstone of all the changes that we're making. And that you're going to see. We have been directed by HUD that absolutely has to happen, given the limited dollars that we have available nationwide for this program. And so we're taking a hard stance on the rent issues and reasonableness of those rents. When you implement rent increases, the possibility if you're charging what the market, if we can't find comps for that rent that you want to charge, we may tell you got to reduce the rent. And that's because we're guided by that one principle. And that's been reiterated to us time and time again by HUD. And more recently, if you received a notice from us in April, we had a meeting with HUD. And that was the biggest issue that they told us we've got to stand by. And I think that is across the board for any housing authority at this point in time.
So there's a poor perception of rent reasonableness and our costs for this is something that we've been having an issue with what we charge are comparable, but it may necessarily and then reduce it. If determine what that rent is not reasonable, then you're not going to prove that applicant to live in we're not going to.
So you're talking about a move-in. That is accurate.
Good morning. I just want to clarify. So, for example, if a rent increase is scheduled December 1st, when is it due to you by?
Yeah, is September 10th.
Okay, that's unreasonable because I get my renewal rates 60 days out, 70 days out. Am I supposed to get them 80 days out? Like we make a lot of concessions with these new rules and things for you guys, but now you're making it literally unrealistic to get rent increases out to you.
So, yeah.
So is that really how many are like that? That's way
Apologies. So we're not only asking for the 60 days. And again, this is something that we've picked up from other housing authorities to help with workload issues and the amount of paperwork that we're getting and to allow us time to work with a property owner. We've also instituted this new policy about receiving it by the 10th of the month. And anything so if you are looking for I'll just go the January 1, we need to have it by October 10th. You send it in to us October 11th, or we receive it October 11th, we'll push you out another month to review. So I'm just looking for feedback on that. I'm hearing one person who's saying, hey, that's not within our practice, and that's going to be hard to do because we're adding more time.
Yeah, and the 60-day notice is the HUD requirement. Is 80 unreasonable?
Yes.
Yeah. I was pushing for 60 is difficult in a lot of cases, and what that does is I can't.
Yeah. I don't know.
So what I heard is that it is unreasonable because you are forecasting leases and rates, et cetera, and that just adds more time from your perspective. And okay, all right. And I'm seeing a lot of head nods about the 10th.
Okay. But, the requirement, the federal requirement for this program is 60 days. And that's something that we cannot manipulate, adjust at all. But any other comments regarding the 80?
So The 60, it's the 80, that's
Yeah.
the problem. So
Okay. Can you repeat that?
going forward, we have to do 80 days now? Or are we attempting to do 80 days?
That was what we instituted July 1st, but you know, this is a forum where we can get feedback if we need to make adjustments or consider if we
So
can.
my negotiation with you would be that, okay, not the 10th, but this issue of receiving proper rent notices, y'all are doing that by state law. What we will not accept are the option contracts. That should be occurring way before your 60-day notice. And what we will not accept as well are leases, because again, that presupposes that we've already agreed to that rent increase, that's been approved. You've locked a tenant into a rate that we haven't necessarily looked at. So those are two hard no's for us, is we want the proper written notice that you would normally send to a tenant under state law, and it cannot be an option contract, and it cannot be the signed lease. Those are things that the options ought to be happening way before 60 days. And the signed lease shouldn't be happening until we've approved a rent increase. So
And I'm perfectly fine with that. It's
Okay.
getting you this documentation 80 days out when I get my rates 70 days out, typically. That's the biggest thing. So. There.
So
There's a huge workload here that just processing your one thing. I just have one house. Yeah, but I've got
Yeah.
1,500 others.
yeah, and I get that. So again, you know, we are dependent on each other, and we are particularly dependent on our housing providers. We want to be cognizant of that. And we only have a certain amount of workers who have a caseload of, say, 350 cases right now that they're handling. And that's a little bit of why we're trying to streamline things. We're trying to formalize and standardize things. So it's easier for a worker to get through 350 cases. Acknowledging, though, that you as property owners have thousands of units you might be also doing paperwork on. So we want to get to some kind of happy median. But the 10th I'm hearing is a little bit restrictive and burdensome. So, you know, that is something that we can talk about internally.
Yeah.
With regard,
Because we are Zooming this call, if you could use the mics as well too, please. Thank you.
with regards to the rent comparable analysis that you guys do internally, would you accept rent comps within the complex? I know the city of San Diego requires us to submit 2 rent comparables if the complex has multiple units, equivalent to, like, say, a 1-bedroom or 2-bedroom that you know, is subject to Section 8 housing. If we have that within the complex, can we submit that?
You certainly can. On the website, there is a supplement that's available in the event that we can't find. We internally cannot find comparable rents in your area. There is a form that where you could submit your own comps for our review.
And do you guys look at those, like put weight on that as opposed to going outside the complex, or
Well,
how is that
we
weighted?
will review and do our research to identify whether those rents are in fact comparable units, and we take that into account when we do our review.
So I think that goes to, a question that was answered earlier. So there may be questions and differences of opinions of how we're doing our comps and how you might be doing your comps. I will say part of our process of streamlining, the County of San Diego, this region is very good at working with each other. And so a lot of the things that we are trying to do is to be in line with the County of San Diego and the City of San Diego and the Housing Commission. So that if you are a property owner who's working in the City of San Diego, but also here in the City of Oceanside, that it kind of looks and feels the same. That's our goal. So if y'all are working with different housing authorities and you are finding some policies there, some processes there that really would be a benefit to Oceanside, let us know that. We by far will take that. So on the rent comps, one of the things that we are looking at is within a certain radius, the same type of unit, the same types, give or take of some amenities. And if we disagree, there is a form that you fill out, you give us your comps, we'll look at them and we'll go from there. Use a mic, please.
So when we go ahead and increase request, we would like, of course, for you guys to go ahead and submit that packet. We'll go ahead. That's missed. Of course, the notice, and then we go and move on to rent reasonableness. So we'll go ahead and pull our comps. If we're unable to find any comps, we go ahead and send you a denial letter, whether it's missing information from the packet, or if we can't find rent reasonableness within that radius, we send you a supplemental, you can find it on our mental form, and you provide us your comps. It has to be unassisted units within the complex, and it'll give you like, okay, you can't do this, you can't do that. It has to be rented within the last 12 months. If it's outside of that, of course, we're not going to be able to accept it. So there is guidelines to the supplemental form if we are unable to find any comps. So we're not going to just straight out say denied because we didn't find any comps. We're going to give you the opportunity to provide those to us. And by the given date, if we don't get those by the given date, then we will go ahead and deny it. You'll have to start the process all over.
What's the question over here?
Oh,
Hello.
yes, Jim and I here. When you showed the form, Metropolitan Water District, but inclusive different in because there are not exclusions. To certain sectors of our society. And so these are questions I have about the public utilities that are regulated.
All right, so I think your question is dealing with utility allowance. Every year, we take a look at our utility allowance schedule. It's broken down into various types of housing. And we utilize, we gather information from the various utilities on what they charge. And that's what we use to develop our UA schedule. We don't need to change the UA schedule if there is a less than a 10% increase in any of those utilities, where we are going to take a look at it later this year to see if we need to raise the UAs. what we're looking at here in the rent increase request form is who's responsible for which utilities when or for the tenant. Is the tenant paying for electricity? Is the tenant paying for gas, water, sewer, trash, et cetera? Once we get that information from the landlord, we use that calculation and we include it in our formula to identify what the rent is, what the tenant portion and what the HAP is. I think your question is more related to the utility companies, and that wouldn't be relevant to the rent increase request form, which is for property owners and landlords.
And then we need to move on to the CSA presentation.
Hello?
Me?
Yeah.
Oh,
sure.
perfect. Mine's regarding the supplemental forms for the comparables. You got the information of whoever's living in that unit. Are you guys reaching out to the tenant when we do the comparables? Or like, what's the point of having the cell phone number for the comparable unit?
Yeah. I think we updated that form to remove that section.
I love that. Thank you.
Yeah.
Hopefully.
Because we could have received your guys' feedback that was given to us and make sure that it is aligned with the federal regulations and have updated the form, not just to make sure that it fits those regulations, but also to do. So the site has the most to be.
Yeah, and if you think that there's information there that is irrelevant or not applicable to your scenario, you don't have to provide that. The housing specialist will contact you if there's information there that they absolutely need in order to process it. We can verify, if we choose to, the rent comps, but you're also sending in all of your paperwork, attesting that you're sending it in true to the best of your knowledge and ability and under penalty of perjury. So at times we will just take your word for it because you're signing it under penalty of perjury. And so, it may be occasionally that we do checks for quality control purposes, but otherwise, and certainly direct personal information from a tenant is not necessarily a route we would want to go.
Next on the schedule is. So we're going to do fair housing updates from our partner agency, CSA San Diego.
Choose too. So I know there are a lot of questions about state laws. So I think this presentation will answer a lot of that as well. So Raquel.
Hello, everyone. As Leilani just said, my name is Raquel Hernandez. I work with CSA San Diego County. Thank you so much to Leilani and Cecilia and the City of Oceanside for including us in this workshop today. Give me a moment while I figure out this clicker. All right, so again, as listed in the agenda, today we'll be discussing a bit of some updates regarding and some reiteration on fair housing. Yes, give me one moment. So today's topic is going to be on fair housing as well as rent increase updates. Some of this will reiterate some of the previously discussed material, but again, it's just a refresher and always important to know. So a little bit about our organization. Again, it's CSA San Diego County. Our mission statement is that we're a nonprofit 501c organization, and our primary mission is to promote social justice, public welfare through programs, services, and advocacy against all forms of discrimination, including housing discrimination, in order to assure equal opportunity housing for all. And again, our services, we are a nonprofit, so we provide free tenant landlord mediation, as well as counseling, as well as fair housing counseling to both tenants and landlords and managers and anyone related to housing. So a bit of what we're going to be overviewing in this presentation. We're going to again discuss the California rent cap, which is AB 1482, reiterating the Tenant Protection Act, as well as some fair housing basics, going over reasonable accommodations as well as modifications, the differences between service animals and emotional support animals, as well as some common questions. So to begin, again, the Tenant Protection Act, which has been in effect since January 1st of 2020, does create, again, a California rent cap, as well as just cause eviction standards. So starting with the rent cap, as previously discussed, rents are capped with the formula of 5% plus the county consumer price index, or up to 10% max, whatever is lower. So again, you can only provide a rent increase once per 12 months or twice within a 12-month period. As well as the consumer price index is found on the U.S. Bureau of Labor Statistics. And again, it does change every year, as previously discussed by Ms. Leilani. And all rent increase notices, as well as previously discussed, I'll just reiterate, must be served in accordance to Section 1162 of the Civil Code of Procedure, either through personal service or posting and mailing, as posting the notice as well as mailing it to your tenant. And again, it is a 30-day notice of an increase for increases under 10% or at the rent cap, and a 90-day notice for increases that are over 10% if you are exempt to the Tenant Protection Act. And again, you may only increase a rent if the tenants are on a month-to-month or lease renewals. So you may only increase for tenants who are in month-to-month basis or upon renewal. So not within a lease, essentially. Okay. And again, as previously discussed, the CPI does change. So it has increased from 3.6 last year to 3.8, meaning the rent cap in San Diego County, including Oceanside, is 8.8% after August 1st of this year, unless you are exempt. So again, I listed up the exemptions, which would be some government subsidized housing, affordable housing for restrictions with very low, moderate income households, as well as school dorms, units under stricter local rent control, as well as new housing built within the last 15 years, and some owner-occupied duplexes, single-family homes, and condos, given that they are not owned by a corporation, real estate investment trust, or an LLC where at least one member is a corporation. And as well, if these, in order to be fully exempt, you also have to provide the exact sentence of the clause, which is in the Tenant Protection Act of AB 1482. This disclosure in all tenancies beginning after, if they have in the inception of July 2020, this statement doesn't need to be in the leases, or if the tenancy predated that, it has to be given to an amendment after. Again, it should have been given to your tenants if you are exempt after July of 2020. So the second part of the Tenant Protection Act also creates just cause eviction standards. Two types of just cause eviction termination standards are at fault just cause, meaning the tenant is at fault, be it a lack of payment of rent, committing a breach of a lease, committing a nuisance, tenant refusing to sign a lease with similar provisions, as well as criminal activity or criminal threats on the property, destruction of the property. And then the second just cause standards would be no fault just cause. So meaning no fault to the tenant's own, that's for the reason for eviction, meaning an owner or an owner's relative is going to be moving in, the withdrawal from the unit from the rental market, as well as substantial remodels and demolitions. And there is stronger protections that have been passed that I'll go into in the next slide regarding substantial remodels, and as well if the landlord's complying with government orders to vacate. So again, as previously discussed, this is an amendment for substantial remodels. Owners still have the right to vacate due to substantial remodels. However, now you must detail the intended work and let the tenant know about their reoccupancy rights, as well as providing the tenant with a copy of the city permit in the notice, and with the work to be conducted, as well as ask the tenants if they would like to reoccupy the property after the substantial remodel at the new rental rate. And this amendment, SB 567, also does increase penalties for landlords who claim a property will be taken off the rental market only to re-rent it at higher rates. And again, this has been effective since April of last. So as far as the types of notices to vacate that landlords must provide to their tenants, tenancies in accordance to the Tenant Protection Act, tenancies that are less than 1 year length is a 30-day notice to vacate, and tenancies that are at least a year and a day in length is a 60-day notice. And all Section 8 tenants, regardless of length of tenancy, is a 90-day written notice. And an important note on Section 8 tenants as well, as reiterating a bit of the previous presentation as well, is all notices do have to be provided to both the housing authority as well as the tenant. The standards, of course, in Oceanside is may be different, but again, it just makes sure that you have provided not only the increases or notices to the tenant, but as well as to the housing authority. And the proper notices for non-payments would be a 3-day notice to pay or quit. Notices of 3-day notice to quit would be only for instances of nuisance, destruction of the property, criminal activity. And a 3-day notice to cure would be for curable lease violations that a tenant must be given 3 days to provide an opportunity to cure the violation. And it's important to note that any notices can never be retaliatory or discriminatory in nature. An example of such notice would be for a tenant who is a victim of domestic violence and who required police presence on the property. There was criminal activity through the abuser. As far as calling the police on the property, providing them with the notice to vacate for nuisance would be illegal. Additional to the Tenant Protection Act would be relocation assistance for all no-fault just cause evictions. All no-fault just cause evictions do require that the landlord give the tenant relocation assistance, which is 1 month of relocation assistance, be it waiving the last month of rent before the rent is due, or providing them with a check equal to the amount of rent 15 days within you serve after serving the notice to vacate. And the landlord does have the discretion to choose between these two options. And moving on to our fair housing portion of our presentation, just an overview of what fair housing is. Fair housing law seeks to address the outcomes of America's history of systematic discrimination pertaining to equal access to quality housing. The Federal Fair Housing Act was enacted in 1968 and amended in 1988. It prohibits and addresses claims of discrimination to specific categories called protected classes. So the federally protected classes include race, sex, color, religion, disability, familial status, as well as national origin. In California, there are additional protected classes, which include sexual orientation, ancestry, source of income, meaning Section 8, etc., as well as gender expression, marital status, gender identity, and age. In summary, what is housing discrimination? Federal and state fair housing laws state that it is illegal to discriminate in the sale or rental of housing, including against individuals seeking a mortgage, housing assistance, and other housing-related activities. These are some examples of some prohibited conduct in rental housing. All of these would be pertaining to one of the previously stated protected classes. So again, for example, refusing to rent or sell housing to a member of a protected class versus not a member of a non-protected class. And some other examples, as well as including even failing to perform maintenance repairs discriminately to one member of a tenant of a protected class versus non-members, and etc. So a particular right for the protected class of disabled tenants would be a reasonable accommodation. Reasonable accommodations are changes in rules, policies that assist tenants, disabled tenants with that ensure they have equal access and full enjoyment of their units or properties. Accommodations must not be unreasonable or impose undue hardship to landlords or interrupt the quiet enjoyment of other tenants. Some examples of common reasonable accommodations would be requests for closer parking, permission for emotional support animals or service animals, and as well as change in rent due dates due to disability payments, SSI, or other government payments. Different to reasonable accommodation, a reasonable modification involves a physical change to the property to help disabled tenants again have full and equal use of and enjoyment of their living spaces. Tenants are generally responsible for covering the payment of the physical reasonable modifications unless it is hub subsidized housing. And a tenant, if they do make a modification, they are responsible for returning the unit into the original condition upon move out. And sometimes landlords may require depositing money into an escrow account for that change to the original unit. Again, common reasonable modifications would be installation of ramps to access the property, as well as any grab bars in a bathroom or restroom, as well as widening the door frame for wheelchaired using tenants. Okay, some more information on emotional support animals versus service animals. So service animals are trained to perform specific tasks related to a tenant's disability, and it's covered under the ADA as well as the Fair Housing Act. And emotional support animals provide support or mental support, and this is protected under the Fair Housing Act. Both of these emotional support animals and service animals are not pets, and therefore not subject to any pet fees, pet deposits. And a landlord may not ask for details on the tenant's disability, but they may ask for additional documentation if not obvious. And state and federal laws restrict weight and breed restrictions and size restrictions for these animals. Frequently asked questions that we get for emotional support animals as well as service animals. Again, as previously mentioned, no pet deposit applies, as well as common question whether it be an emotional support animal or a service animal, if they cause damage to the property, this would allow a landlord to deduct the damage from the security deposit only upon move out. And whether or not a reasonable accommodation can be denied, it can only be denied if it is unreasonable. And again, the landlord cannot ask the tenant about the nature of their disability. So just to wrap up what we've gone over in this presentation, again, AB 1482, the Tenant Protection Act, creates the rent cap as well as just cause eviction standards. And fair housing laws protects against discrimination in housing. Again, reasonable accommodations are exceptions to the rules or the language in the contracts or rental agreements, leases, etc. As well as, again, reasonable modification would be a physical change to the property. And again, emotional support animals and service animals are not pets. And if you have any doubts on anything that I've gone over in this presentation or in general regarding fair housing or tenant landlord law, you can always feel free to contact CSA. So you can contact, my name again is Raquel Hernandez, and I work from the Oceanside satellite offices. I'm in the Chavez Resource Center Monday through Wednesday at 8 to 4:30, as well as the Libby Lake Resource Center, 8 to 4:30 p.m. I speak English and Spanish, and we can also assist in English, Spanish, and Arabic. And our phone number is listed below, as well as our website that you can fill out a form and inquiry, and we will get back to you as soon as we can. Yes, phone number 609-444-5700. I'll take any questions.
I'll be handing out mics just as a reminder. People on Zoom, if you do not have a mic, they cannot hear you. People in here can, but people on Zoom cannot. So I'm gonna pass out mics and we can go ahead and ask questions. And
I'm going to
comments that
start
we have.
our questions from the ones that I've received. Many of the questions that came in that were filled out are more related to 1482 and landlord tenant issues. So I think most of them were answered, but just for clarification, on 1482 related to tenant protections and the relocation and displacement issues. So the question was, do I really have to pay relocation for every tenant that moves out because they've been evicted? And that all depends
For all no fault, just cause evictions, if the Tenant Protection Act does apply to you, yes.
Then the other questions that we're getting, as we all know, cost of living has gone up for everyone, whether you're a tenant or landlord. Insurance is one of those big ones that has been going up. And so many of you may have been caught before rent control came in and stayed at below market rents because y'all were doing the good thing and you had sympathy for your tenants that may have been seniors or having a difficult time. And so your rents were below market and income's 1482. And now we see increased costs. Is there a way in which you can raise the rents above what 1482 says you can do to catch up with the market and to help with increased costs?
If the Tenant Protection Act applies to you, you are capped at the same standard as everyone else.
So you kind of got stuck
Oh,
in,
no. Mhm.
in
Oh,
a
no.
bad place. If you are subject to 1482. If you are not, then those rules don't apply. And really, it's only the newer stuff that's been built within the last 15 years. If you are only, this is your retirement portfolio, you only have a couple of units and it's just a single family house, that's a little different. That's exempt. But
you've
in
given
most
notice.
cases, most cases, you're kind of caught in a bad position at this point. And that relates again to the maximum amount per year. You're capped if you're under AB 1482 to that 8.8% as of August 1st. And then there was a question related, is it a 60 or 90-day notice? We went over that. The 90-day notice is related to rent increases above 10%.
It is also, so was that pertaining to a rent increase notice or a notice to vacate?
Rent increase.
Okay, so for a 90-day notice for a rent increase would be for exempt properties that are over 10%.
And then, this is a little bit. Questions related to, this is more for mobile home residency law in 79821 about subletting rules and rent control.
What was the question?
So related to, these are civil code citations, rules for subletting in rental communities, whether they're mobile homes or rental. How do those apply?
So if I believe, correct me if I'm wrong, George, but as long as there's no clause against subletting in the lease, that should apply. They are free to sublet unless stated in the contract.
And again, on rent control, the city of Oceanside only has rent stabilization for manufactured home communities, but it is something that, again, that city council may be considering at the September 3rd meeting. And then there was a question related to pro bono attorneys. Also a little bit related to the September 3rd action. Council will be considering a program like a right to counsel or an eviction prevention that might provide that type of services. But if you're aware of the City of San Diego's program, that program is a very limited program. It is contracted out to Legal Aid Society. So it's not necessarily for landlords, it's more for tenants that are more vulnerable and don't have the ability to seek legal counsel. There's a feeling that there's a imbalance there between landlords and tenants and the ability to have legal counsel when it comes to eviction proceedings. So that was another question that was asked, but there are certainly other places that you can get legal referrals and services, whether it's volunteer lawyers. The courts have great self-help centers there as well. So there are existing services out there outside of pro bono. CSA as well is also a great resource that we contract with for the city of Oceanside. And George is going to make a comment on that as well.
Sure.
I believe he said the San Diego Volunteer Lawyer Program.
Yes.
But again, CSA can advise both landlords as well as tenants. All right, and then yes, go ahead.
A comment and a question.
Mhm.
On the ESA, there is a restriction, the 486. Restricted. The VS. Have a. The. With, it says, can we require renter's insurance with dog bite when it is a dog on an ESA? Because unfortunately, when a pit bull ESA attacks a small child, the landlord gets sued. So is it allowed to be required to have renter's insurance for an ESA?
As far as the similar policies that are applied to pets and ESAs, the only thing that I'm aware of is as far as vaccines and those mandates. But as far as insurance for animals, I don't believe that is the case. Again,
Can we require it? So we can require renter's insurance?
not for emotional support animals or service animals.
If you're at owners to complete liability. They.
As an answer to your question, as for pet. Sorry. Be a canine, has to be a dog. No longer can you have a Shetland pony. They wrote that out of the law. I think like it was actually Shetland ponies were allowed, but they no longer are. It's just strictly canines, and they must have certification that they are a service animal. An ESA animal does not have to be certified, but they do have to have vaccinations. People say, how do I vaccinate a fish? Well, you don't, but you know.
But no requirement that we have the requirement of renter's insurance to cover the dog.
No, sir, there is not. I mean, you can have renter's insurance, but that's for a lot of people construe a rent insurance as insurance is to protect the tenants.
There's also a key in all property management now to create the liability to be able to cover both the tenant and the owner in case a guest comes over and falls and then sue the owner. So then the liability insurance that are covered under the renter's insurance covers both the owner and the tenant. Yeah. Yeah, but I get that. Using the renter's insurance to fix the property is BS. But if the renter pit bull ESA and that pit bull ESA attacks a child, the person who gets attacked is suing the landlord. They're not suing the renter because the renter has no money. So they're going to go after the landlord because they have the asset on the whole list. So the renter's insurance at that point, at least the renter's insurance is a stopgap to help slow the attack on the owner.
Yeah. So I would suggest on questions like these, obviously, I mean, I think that there is some disagreement and there are needs on a tenant side and then on a property owner side. I would advocate for you all where you see these policy issues and laws that may not be, is to contact your state legislator, your federal legislator, your apartment associations to advocate on your behalf to changing, it's really changing the law.
Renters. Both.
They do something that floods the whole property, something like that. Covered by a different insurance, and the renter's insurance. The renter's insurance will cover the renter's furniture, stuff like that, putting them up in a hotel if the property gets damaged. as a result of something that the tenants didn't do. But if it's something the tenants did, like their dog or something like that, I believe it may even be required that, or the tenants carry liability to landlord insurance. As a property manager, I'm supposed to make sure that the tenants have it. So that could be the insurance that you're looking for to cover the. Right. Oh. Right. Oh. Yeah, yeah. Right.
So y'all are learning from each other here today.
All right, is there any more questions? Yes. Oh, do we have any? What's that mic?
To increase the rent. CPI is 8.8% in San Diego County. So would you go by county or you don't go by city by cities?
The CPI is countywide, so that's the San Diego County, so Oceanside would be covered under that.
Oh, okay. So you don't go just go Oceanside or CPI and multiply it. So
No,
you
it's-
go,
it's
you
the
check
county.
with the.
Yes.
Okay, thank you.
This might be a question. It's a little bit of HCV, but I think more suited for landlord tenant issues. So the question is that the property owner and the housing authority have agreed and approved a rental rate, and we're good to go. Now we have a tenant who refuses to sign that lease. What are the landlord's then alternatives for a tenant who's in place and refuses to sign a lease at the rate?
So I believe that is under no fault, just cause evictions for refusing to sign a lease of the similar provisions.
Right. So it would be outside of our purview, that we would leave that to you all and your relationship, and sounds like the path is the just cause eviction.
I think George would like to add to that as well.
So everyone heard that response? Another question we have, and this is, well, it's homeowner, it's landlord, it's this issue of you all have a trash dumpster on your property. But everyone around the neighborhood knows you have this big apartment complex dumpster and they're putting stuff in there. They're availing themselves of your dumpster. What can you do about this? And that's a civil issue between yourself as a property owner, landlord, and your neighboring folks. In terms of a city response, I'm not sure that there necessarily is a city response, because again, it's property owner to property owner.
They'll pick up some of the stuff that there for like a couple of times, once like, oh yeah, I forgot what they call it. A couple of times, then the city has been picking it up.
Yeah, so we do have bulky item pickup for our community. And we have seen and heard this happen where folks just drop off somewhere and then that property owner knows it's Fred's next door and takes that dishwasher and moves it right in front of Fred's house. That's a lot of back and forth, but these are civil issues that are outside of the OHA. So good neighbors.
combination lock.
Question on the Tenant Protection Act.
Yeah.
So if you own the property in your own name, or even an LLC of which a member is not a corporation, then it doesn't apply. Is that correct?
If you've given them the notice that's in
If
the
you give
tenant
the
check.
exemption. notice,
Yes.
yeah. Okay. That's what I thought.
Thank you. Okay, is there any other questions?
Vacate, and there's a big difference between a notice to vacate and an eviction. So notice to vacate, it must stipulate on there that the person, that they are exempt or not exempt from AB 1482 and 567. If you get the newest car forms, it's going to have that option there. Don't get it. I mean, I suggest that you don't just download something from the internet. Get something that's in accordance with California law and states on there. Because a lot of judges, if you do decide to file unlawful detainer against these folks, the judge will throw it out because you did not stipulate on there whether you were exempt or not exempt from AB 1482. So please do that. And just on a different note, a lot of homeowners, property managers, I can't stress enough that you have a move-in inspection and also a move-out inspection. And the earliest you can give out a preliminary move-out inspection is 14 days. Okay, and after that, you have the last inspection when they move out or upon move out. So I strongly suggest that you do that, not only to protect their security deposit, but protect you from any damages that they cause to the property. And said, no, I didn't do that. Well, you did do it because I have proof here. So it's, it's better to not walk over dollars and save pennies. Download those forms. You can go to the nearest Board of Realtors, and to landlords, they'll sell you those. They're not very expensive, the newer forms, the newer car forms. Thank you.
And I believe that's also free resources on the San Diego Courts website as well. There's no more questions. Again, thank you so much for your time. And again, feel free to contact us with any questions or concerns, whether it be about yourself or a specific tenant if you don't feel comfortable asking in front of the audience today. Thank you.
Hi, everybody. We're going to shoehorn another presentation. It's for the temporary tenant-based rental assistance program that we do through the city of Oceanside. We have the support, the providers here to do a quick presentation on that. Just so you know, this is something that is outside of the Housing Choice Voucher Section 8 program. It is temporary tenant-based rental assistance. And I'm going to ask that the folks from Interfaith Community Services come and do a quick talk.
Thank you, Ray. Good morning, everyone. My name is Christine Whitworth, and I'm with Interfaith Community Services. So the first word is very unique. It's INTER, faith, like you have faith in something. And so our website is interfaithservices.org. So the information I present today will be on our website as well. Our program, I will go into 3 main criteria for y'all. I'll keep it brief so that you just have an overview of how our program works. It is also under HUD, the Housing Urban Development Department. It is a federal grant. And the way our process works is there's a criteria for the tenant to potentially get short-term partial rental assistance. And it really focuses on making sure that there is not an eviction in place and that they don't have to move out and that they can be self-sufficient, technically within 120 days, but for purposes to assist, think that for you all, they could potentially get an initial 4 months of partial assistance. So the way to qualify is they need to be residents of the city of Oceanside. They do have to have a current lease and they cannot be behind on their rental payment. So they can't be in arrears. We can look at helping someone if they have from you a signed dated lease of a future move-in date. And if that is the situation, potentially we can help with covering the deposit and the move-in cost for that tenant. The other part of it is that there's income limits. So to really keep that clear for y'all, if they are under the 60th percentile for gross income within households of Oceanside, we can look at helping them with partial payment. So there's going to be a 40% of households whose income within Oceanside won't qualify. I want to let you know that it is very rare for us to talk to someone that's in that 40 percentile. Before I go any further, I just want to say to y'all, I really appreciate the courage and the effort that it takes to be landlords. There's a lot that goes into it, and we function from that appreciation when we work with the landlord and we work with the tenant. So the basic criteria are those 3 factors. And the other part of it is the assistance is going to be factored on calculations under HUD that you heard a little bit about today. And what happens is I will meet with the potential recipient of the tenant assistance. I will get all the numbers in place so that when I reach out to the landlord, I have specifics for you. And everything is usually conducted through email. I can definitely go and meet with you in person if for some reason that's easier. And essentially it comes down to there is going to be a housing assistance payment contract that really just spells out the terms. This is how much their standard rent is. This is how much we can assist them. And it will let y'all know for how many months. Just think 4 months of rent initially. In some cases, we can do a recertification, which just means we are extending the rental assistance past the initial 4 months of the term. And then the process is the thing that makes it easy for y'all. There's only one of us. That's me. So in the process, you're going to have my email and you can reach out to me with any kind of questions, concerns. And I really work to be very quickly in a process that does take a long time. We'll explain it to the tenant. I'll jump into it a little bit so you guys have an idea. The process will take a meeting with the tenant. They need to bring me all their income verification and their identification. We look at some other factors per HUD. It's all through Section 8 criteria that we have to meet. They sign forms saying they want to participate, and then I will contact you and I will email you the forms for you to review and then sign off on. If you agree to it, and it is your prerogative to agree to it, I then will do a final meeting with the tenant and I will issue them their voucher, and then we can start looking at payments. That usually in total takes from the first time I talk to someone, the potential tenant who can receive the assistance, the whole process usually takes about a month. So it definitely is not an emergency housing kind of assistance. And if everything moves through very rapidly, everyone responds to my request, it can be as fast as 2 weeks, but that is not really realistic. I want you guys to know that it is going to be a month and sometimes longer if there are delays that are outside of our control in processing the request. Did any of you guys have any questions? Yes. Thank you for asking that. It's partial rent. It's not the full rent. Sometimes it can be a very substantial amount of rent, like going into the 80 percentile. And there is a hardship category based the main criteria is the lack of income into the home, but it is partial. And the expectation with the funding is that the 4-month criteria, it's just really about gap funding, because the expectation through HUD is that the tenant will be able to be self-sufficient again within those 4 months, the 120 days.
So what happens after the 4 months if they're not self-sufficient? Like what happened? Do you stay with them or are they terminated from your program?
We will look at if it's warranted, because we're very specific when we start working with them of putting together a plan of how are they going to be self-sufficient in 4 months. But if it makes sense, and it's usually circumstances outside of their control, then we can look at extending it. Definitely.
So 2 more questions. First of all, do you help with the deposit? And second of all, if you do extend it, how long do they stay in your program total?
If the deposit can be assisted with, if it's that future dated lease, and there's other factors that go into it, but the short answer is yes, if they have not already made the deposit. And we definitely can look at helping with that. And then what was your second question?
If they do need to be extended past the 4 months, how
yeah,
long do you
okay.
actually stay with them? Like what's the total length that the program can help them out for?
We look at, it can be 120 days again, so it can go in that another block of 4 months. We will look at doing it shorter because the whole spirit of the partial rental assistance is to regain self-sufficiency within a short amount of time. But there are those variables that we can look at. And of course, the landlord, you are kept in the loop of each criteria we're dealing with and the timelines we're dealing with, because the tenant will sign a release that I am able to communicate with you freely in order to provide the services. So it's a big thing to me to keep the landlords in the loop and to communicate clearly with them so they know what's going on. Anyone else? No question? Or I can just walk over. Whatever works for you.
Okay. Sorry about that. In the cases they're no longer able to, or they do not follow the plan, or they do not get into that situation, is there any resources that you give the landlords then to help return possession back so that they have a income flowing property again?
I don't understand the question. Can you read?
So in the case where the tenant, the person that you're helping fails and they do not go through with, they no longer can afford to pay their portion of the rent. Is there any, and the 4 months has ended and there's no rent coming in at that point? What resources do you give to landlords to help them return possession back without having to go through a 6-month eviction process?
Yeah, everything like the 60-day notice will stay in place because you never lose possession. The landlord's rights and responsibilities, they stay the same. You don't lose anything by helping someone or allowing them to be helped out within that 4 months. Okay. Thank you.
We use the program and we still qualify the applicant to make sure, for us, it's 2.5 times the rent. We make sure they still qualify on their own so that we don't get into that situation. They're coming in on the back end. Once you have a lease in place and you have qualified them, then they're going to come and provide you that rent. So it's not necessarily it's make sure you qualify them first that they can pay the rent. Once that program ends, they should be able to continue based on your qualifications.
Okay, thank you for clarifying that. Yeah, you should screen them just like you would anyone else.
If
Does anybody else have a question?
Actually, I just want to make a comment. My name is Cecilia Brandran, and I'm in our Housing and Neighborhood Services Department, and the tenant-based program comes under our side of the house. So what we want you guys to know is this is an opportunity for you as landlords. If you have a client in your system that is struggling, maybe somebody in the household lost a job, maybe they are having a medical emergency and they're not going to be able to work for 2 or 3 months. This is an opportunity for you to connect that client with Interfaith for the temporary assistance. So it's really an opportunity so that household doesn't go into arrears, doesn't go into foreclosure, doesn't then get evicted. So consider it like a temporary opportunity that you can present to your clients, to your people that you're working with in your communities, that, okay, I know this person's struggling. I know this household is struggling. They probably don't know about this program. Let me tell them so they can contact out to Interfaith and get that assistance before they drop and then they're out of the community. So just consider it that way. And it's a partnership that we have with Interfaith. So thank you.
I'd liken it to those tenants that you have that have just hit a slight bump in the road. Not that they're 62, 66 years of age, their retirement, their income's limited. It's for the bumps in the road, the little hiccups that people face. I'm going to plug another program that we have as well that we're looking for assistance and that you all need to know about. I had put some flyers earlier. We have a program where we will reimburse tenants for their rental application fees. So if you have folks that are coming in and you know that, hey, this might be of a little assistance, liken it to, you got a family of 6 and 4 of them are adults and you're going to ask for a rental application for 4 of them. That's a big hit. We have a program that if you're income qualified, that you can be reimbursed for that $65 or however much you charge per application so that it doesn't necessarily hurt them, but that is available for income qualified persons. It's on our website under our rental housing programs. So that's another program for any residents that are coming forward that you think might be able to assist. And I'm going to tell you what is considered low income is pretty high. So our San Diego County median for low income, or the median income in San Diego County, is $134,000. So low income is 80% of that. And so that probably includes many of us in this room. So just saying. So we have a few more minutes. Susanna's not slated to come on until 11. We have a few more questions that did come in that might be answered by CSA, by ourselves. Oh, there's one.
Wondering, do we have contact information for you?
Yes,
For
I have
Interfaith?
flyers. I'll leave them up there. And there is a main number on the bottom of the flyer that you can contact. Sure. Anyone else before I excuse myself?
This isn't necessarily a question. This is more of a housing choice question I wrote down, but I'm about to leave soon. I was just curious, are we going to update the communication as far as approvals outside of just mailing them? Yeah, the rent change increase.
So our standard mode of communication is mail, because that's the easiest way to communicate not only with landlords but also our participants. Sometimes emails die for whatever reason, so we know what the mailing address is for some folks. At this point, we're still doing mail only, but one thing that we're looking at is modernizing our technology, our management software. That's something that has been going on for a couple of years now, and I'm hoping that we're close to finding a way to do things electronically. Not everything, of course, but that rent change notice is something that we're looking at potentially sending it out electronically.
Yeah, I was just hoping like maybe we can get like automated, it's approved type of
it's not gonna
email,
go-
because
yeah.
sometimes I get the approval after the fact in the mail or something of that nature. Then we have to double back and do a bunch of corrections. So
Yeah,
that was my biggest question.
Yeah, it's not going to be immediate like that, where, the package is on your porch and you have a picture of it. But, the baby step of perhaps sending the PDF of the rent change notice across the board is something that we're looking at. All right.
Thank you.
Yeah. I'm going to throw some new questions came up, and I'm not sure. CSA may be able to answer some of these and some might be for ours. But the question is, are new leases required every year if a tenant continues in property? Ray?
No, a new lease doesn't need to be in place. You know, if you're changing the terms, of course, you need to include a lease, but they can always just transition to month.
The lease, it reverts to, it just graduates to tenancy at sufferance. That means it goes month to month. If the lease, they're going to add new verbiage to the lease, then they have to add an amendment to it, or they're going to continue on the lease. But no, you're absolutely right.
Okay. Is a new inspection required annually if a tenant remains in property?
I'm assuming this is for Section 8 Housing Choice Voucher Program.
Yep.
For tenants, we do a biennial schedule. It's every other year we do a unit inspection. Give or take every 21 months, because we have to build out in the event that, there are findings that need to be cured. So we have a 21-month cycle for ongoing HCV participants.
And that might have been answered by Susanna in her presentation. This one is more of a civil law issue. Are landlords allowed to offer rent discounts for military or seniors? I think y'all do as an industry provide some sort of move-in incentives, but in terms of our program, I don't know if there's a direct correlation.
I think this is across the board. Lowering rents is always a good thing. So in the event that, you're going below market in renting to a tenant, that's fine. For Housing Choice Voucher Program, it's an income-based program. So the tenant portion is going to remain the same for the tenant based on, the income. So probably the HAP, the housing assistance payment amount would be less. So we're all welcome for, discounting rents for, not only veterans, but all parties.
Follow up on that.
Correct. We'll do a lot of complex.
To everybody. You're not offering that just to the military.
So tickets for Disneyland, military rates, but when it comes to housing, abide by fair housing laws. Right. Last question. This one's a little bit of a more specific one, but I'll ask it anyway. Smaller product, Section 8 tenant is moving in. Your gas and electric, because you're small, are metered to the tenants, but then but the billing is going to the owner. what is the best way to calculate water and trash expenses so that all tenants are treated fairly? And then what about those expenses for common areas? How does that get calculated into cost?
I can answer that, sorry. Yeah.
Appreciate you volunteering your time to participate in our workshop.
We allocate based on apartment size and number of individuals, so it's a RUBS calculation.
What do you use for weighted average?
We use both, so we look at the size of the apartment, we look at the number of occupants.
All right. With that, George? I know. You're everybody's.
Lord, hey, I want to see how you're divvying this up and what the meter readings are. As a renter, you can call UCAN. They're a wonderful watchdog.
Calculations at move-in. So we have a sheet that shows what the calculation is. We have sub-meters for gas and electric, but then for the allocation, that is for each one of those utilities. I'm sorry? We don't provide bills. Really?
Did everyone hear that? So just to recap that, without the mic, is that in terms of the billing or the calculation of how that gets divvied up, that some folks are proactive and transparent and provide that at move-in so folks know, then they get billed that. This particular property owner, landlord, company does their own third-party vendor, they get billed. If a tenant wants that information, they don't have to be provided that information. But if they request it, that you should be providing that in writing and within 15 days. That sum it up? Great. One more.
Made their units available. That has changed with Section 8, and now we just go to affordable housing. However, it seems like we're not getting any Section 8 tenants activity through that, method.
Yeah.
So is there a more specific Section 8? And that didn't seem to generate any, again, Section 8 tenants for us.
Email front desk or call. Email's probably better with the details of like units coming available. And then our receptionist will send it out to all the housing specialists. So if we have anybody on our caseload that's looking to move, we can share that information with them. So that's probably like the more direct, like handoff compared to the affordablehousing.com website. We do give that link out though, so.
We do give that link out and we utilize that link. We've been told standardize, utilize that. That's how we do our rent comps, is through that website as well. So it's good to always advertise your units there and have them up there because that's where we pull our comps, quite honestly. No further questions? If you don't mind, we can probably start 5 minutes early with Susanna Sandoval's presentation on housing inspection processes.
Yeah. Right. Hi, everyone. Thank you for coming. I see familiar faces. My name is Susanna. I'm the inspector for the City of Oceanside Housing Authority. Our role here at the City of Oceanside is to ensure that all assisted units meet standards of safety, sanitation, and overall good conditions. This means that in every unit, this means that everything in the unit must be functioning properly and suitable for occupancy. All right. So for inspections, the OHA is required to perform inspections, initial inspections, which means at move-in, units must pass before the rental assistance begins. Inspections must pass before the system begins, meaning that the unit is not recommended to move into the unit until the unit passes inspection, because we don't want them to be liable for an entire month's rent or until the unit passes inspection. They're on the program because they can't afford to pay the rent, right? And then number 2, biannual inspections every other year. So after the tenant moves in, the next inspection would be 21 months out from the move-in date. So it's 21 months from the original move-in date. If it was inspected in July, it'll be re-inspected in April of 2027. So almost 2 years. Both owners and participants are given 30 days to make the necessary repairs from the original inspection date. No extensions beyond the 30 days will be granted. It is always our goal to pass a unit. However, when there are deficiencies that require attention, we are obligated to fail the inspection in accordance with HUD regulations. Additionally, supervisors may conduct quality control inspections to ensure that all units are properly inspected. So my supervisors will randomly pick units and re-inspect it to make sure that I'm doing a good job. All right, abatement. Abatement occurs when a unit fails biannual inspection and the owner has not corrected an issue during the 30-day period. The HAP, which is the housing payment, will pause until the corrections are made. There are no retro payments. If the unit fails inspection and it's the owner's responsibility, the payments get abated, but meaning stop. So if it's the tenant's responsibility, the tenant may get terminated from the program. So there's 2 outcomes for owners and tenants. So The OHA strongly encourages both owners and participants to review the inspection checklist. So you'll see on the back of your inspection letter, you'll see a inspection checklist. This is to give you an idea of what we're looking at when we go to do the inspection. But anything in the unit that is not working or broken, I would suggest you guys fix. Okay, this is just to give you an idea. Policies do change, so it may be updated in the next month or two. So it may never always be the same. So I strongly recommend that you do an inspection before the. Keep in mind that HUD. The OHA recommends that you review all notices carefully. They are mailed to the address that we have on file. Okay. So if you have a corporation and your address is to the corporate office in San Diego, check with them regularly to make sure that you're getting your notices promptly. I think that's it. Pretty short, but anybody have any questions? Yes.
A tenant is making it difficult to come in and make the needed repairs. So like they aren't giving us permission to enter, they're not being home for appointments, they're just making it difficult to get the repairs.
So that would be a tenant responsibility. If they don't let you fix something, then they can get terminated from the program. And I do let them know that, especially if an owner has told me or emailed me and says, hey, Susanna, the tenant won't let me fix it. So then when I talk to the tenant, I'm like, hey, you need to let them fix it. Otherwise you get terminated. Usually I talk to them or they get the termination notice and they're willing to let you do whatever you have to do to pass the inspection.
Would it be recommended to go through you or just do a 24-hour notice to enter and just fix?
You can do that first. And if that doesn't work, then you can come to me. Yeah.
Should I go through the dates of my properties and when they're up for renewal or inspection?
You can contact the front desk, they'll have it, but usually you get a 2 week to a month's notice. Typically we have to give the tenant and owner a 2 week notice to let them know that we're going to inspect. So, yeah.
We followed the
Yes, anything that, we're just an entity helping them with the housing, with the rent. So everything that you do, you have to still go by the law.
It's to the 30 calendar days to make the necessary repairs. If the tenant is, non-responsive and it goes past the 30 days because of the tenant, do we get reimbursed for that once it does get repaired, or do we just lose out even though it's the tenant's fault?
So what happens is that, let's say that the unit didn't pass inspection today because of the tenant. So we would terminate the assistance August 30th, the 31st, how many days it has. So you still have a month's notice to let the owner know that we're going to be terminating us. So for abatement is different. Abatement, we stop the first of that following month. And for the termination of the tenant, we stop the end of that following month. Mm-hmm.
One more. What if it takes longer is to make repairs that are procuring certain flooring or parts or whatever it is to make the needed repairs?
That's why we as a department suggest that you go take a look at the unit before, because we can't allow more than 30 days. There's a certain, HUD has regulations on what dates we have to have things completed, either stop payment or the unit has to pass. So that's why we're so strict on that 30-day.
So a lot of pre-planning work before an inspection is what
Yeah.
I'm hearing.
Debbie?
Debbie, you're working for us now.
I will tell you that if you get abated, and I have been abated, you cannot charge the resident their portion of the rent during the abatement, nor will you receive money from housing. So that means during that whole period, all that money gets credited out until you correct it or the resident has moved or whatever the situation is. You have to write it all off until till you come out of abatement if they continue to live there. So be really careful.
Thank you for that.
So again, I still hear a lot of pre-work unless you want to get caught up with a non-revenue generating unit.
Yeah, and that's why I really emphasize to owners and tenants, it's not my priority to fail a unit because that entails more work. There's only one inspector for the city of Oceanside, and from paperwork to inspections and logging and everything. So my first priority is okay. So that's why I really want your guys' help, and I always try to speak to tenants as well too, so we can all work together and make sure the units pass. Any other questions?
Hi. The response.
So I would encourage everyone for to make sure that your leases detail everything that the tenant is responsible for. Because sometimes owners do put in tenant is responsible for light bulbs and sometimes they don't. So I never know. I put it under owner until I'm told otherwise. And because it could be an electrical issue sometimes. There's been times when people just try to change a light bulb and it wasn't the light bulb. It was actually an electrical issue. So I would advise for it to be looked at thoroughly. So that's why I put owner, because electrical wear and tear is owner responsibility. The use of the unit should be tenant responsibility. And I do emphasize to the tenant, but every tenant is different, that they do need to take care of the unit. But that would be up to you if you want to help clean the unit or make it sanitary for them to be living in there. But technically, if that's the cause, then they would have to do it themselves. And
My specific. Owner responsibility. But how? Then
The California Civil Code 1941.1 is the implied warranty of habitability. And that states that the landlord is responsible to make sure that the unit is habitable 365 days a year. The landlord is not responsible for the housekeeping of the tenant. If the tenant does not, of course, I stress to landlords to not to be afraid to use an addendum when they're signing a month-to-month lease agreement or a lease agreement, a month-to-month rental agreement or lease agreement. Use that addendum. That's what it's there for. And add the verbiage that you need them to recognize that. Let's say, they're responsible for the common areas of the unit. They're responsible for everything to do with the units, including housekeeping. Now, if the tenant is not making the upkeep of the unit, and there is a violation by your good agency, then the landlord has a right to give the give the tenant a 3-day notice to perform or quit. Don't be afraid to use those 3-day notices to perform or quit, because there's huge consequences for that if they do not perform or they don't quit, then if they don't perform, then they're going to lose their Section 8 voucher or their assistance from the county or the city, I'm sorry. So don't be afraid to use those addendums and hold true to it by utilizing those 3-day notices to perform or quit. Because in the end, yes, you have 3 entities. You have Section 8, you have the tenant, and you have the landlord. But in the end, it's a contract more so binding with the tenant and the landlord. So 3-day notices to perform or quit. That's what I always stress that you use. Thank you.
Just a point of clarification, with those 3-day notice the performer quit, do we also send them housing? Including the HOA violations and stuff?
Do it.
Perfect.
That way, you know, and you have a paper trail of why you're vacating this person.
Question? So basically, if the unit fails inspection today, then abatement will start 8/1. And sometimes accounting has already distributed that money, so you may get it 8/1, but then they're gonna try to collect it back. So just make sure that it passes inspection. And then terminations, they get terminated at the end of the following month. So just remember, if the unit doesn't pass by the 30 days from, let's say, July, then payments would get abated if it's owner responsibility on 8/1, if it's tenant responsibility at the end of August. Okay?
How about if we have, what is the usual reinspection time? Like, say they get a violation, one of the sockets is out, and the guy's like, I got an electrician right here. He fixed it later this afternoon. How long before you'd reinspect and verify that it's?
So if somebody tells me that they're gonna fix it the same day, I'll probably go the same day to avoid me having to do a notice. And then just keep in mind, when you call me and you tell me, so after I do my last reinspection and there's no more scheduling reinspections, now it's the owner's and tenant's responsibility to contact me to schedule one, okay? So after the 30 days, I will not be scheduling any more inspection, as it's your responsibility. When you call me, I will try to go out there in the next business day or 2. So I will try to I'm not trying to withhold payment. So I will try to get you paid as soon as possible, okay?
So do you accept pictures instead of you having to come out of something cosmetic or aesthetic, like let's say broken cabinet door and they repair it? Would you accept that having to come out and just write it off?
It depends on the situation. If I can confirm that that's that unit, but sometimes I have multiple units and they all look the same, or I have to test something, then I can't accept that.
Is that okay?
To
ask has to be Section 8.
What is your question?
I've heard that deck or patio needs to be inspected by professional contractor. Have you heard that?
Yeah, I think that might be outside the scope of our knowledge today. Who would they contact? Code enforcement? Yeah, I think that's more a code enforcement question or building enforcement.
You would contact her. So for permitting issues and inspections, you're going to contact our development services department, building inspection. No, it's not here in our office.
to have the deck and patio inspected needs to be certified?
I'm going to say always government bureaucracy. You need permits for re-roofing. You need permits for water heaters. You need permits for fencing. All of these things need permits. And when there's a permit, typically there's an inspection.
Right, but I heard it has to be done this year or.
Yeah. And again, that's not within our area of expertise. So I would contact Development Services on that.
Or 326.
Yeah.
The state bill, right?
Yeah, so it just states that apartment buildings with, I think it's 3 or more units, need to get their balconies and stairs inspected, and it's been extended, and it's only been extended till the end of this year. You have to contact, I have a bunch of slides I can share with you after if you want, but you need to contact a contractor to do those inspections. So yeah. No, it can be private. I can share the information with you after if you want.
Thank you.
So thank you all for being a network of folks here that are able to share the wealth of information with those who are smaller landlords and property owners. Much appreciated. So I'm hoping that you are not only getting information from us as a housing authority, but you've learned much from your colleagues here today. So I have found it particularly helpful.
So landlord reminder, landlord and tenants are given 30-day calendar days to make the necessary repairs, no extensions beyond the 30 days. Landlords and tenants must contact the inspector to schedule the re-inspection, and landlords should review inspection checklist on the back of the inspection notice. So I will put some out there for you guys to pick up if you guys want a copy. Okay? Thank you.
Somehow we caught up with ourselves in our overtime, but we have an update from our accounting department or division. I'm sure these are questions you're going to want to have answered too, because this is all about the money.
Good morning. I'm not gonna push those.
Oh.
Okay.
Does she have a presentation?
Do you have a presentation? So Ebony, you want to introduce yourself?
Oh. My name is Ebony Hunt. I'm the accounting tech for the accounting department, the Section 8 specifically. So I'll just give you a couple of reminders because I'm sure after all of this, you want to know when your money is coming, right? Maybe a little bit. So payments are made on the second business day of every month. Second business day of every month. So if the second is on a Saturday, you're not getting your payment until the Monday, if that makes sense. And then we always do a mid-month payment for anything that like if you guys had a rent increase or any changes, but your normal payments will come on the second business day of the month. Anything outside of that will be a mid-month payment. So you'll typically get a rent change notice. The rent change notice will be if you increase your rent or if the tenant income has changed. So that gets submitted to the housing specialist. And let me just put out this little notification for you guys. I pay what the housing specialists tell me to pay. I make no changes on my own. I don't have any say in that. So you'll get this rent change notice that tells you that either tenant portion has changed or the housing assistant portion has changed. That will tell you that, let's just say the date of the notice says 7/29 and the effective date says 8/1. It's very important to pay attention to the effective date and the date of the letter. Just in case they are doing a retro for you, let's say the notice says 7/29 and it's telling you that the effective date is 7/1, right? But you already got paid your 7/1 payment, right? It was probably something less, could be something more. but that's telling you that we made the change and we know that the change is made in the system. If we owed you money, that means it's coming. If we paid you over, that means now that we have to take money back from you on the next check run. That makes sense. I don't want to go too fast. On the opposite, if we owe you more money, that means the tenant owes you less. Same thing. If we owe you less, the tenant owes you more. The two combined will make up your contract rent. And again, how it says 7/29 there and the effective date says 8/1, I'll let you know, we run our housing report on who we're paying probably a week before the second business day, right? I need to have everybody who I'm paying, I need to make sure it's approved. I need to get it to our finance department so they can get it to the bank 2 days prior to the second business day so everything gets done. So this notice is telling you that the change for 8/1, but I've already submitted payment for 8/1. So that means, yes, I know that we owe you a payment, and that will come in that mid-month check run. That makes sense? So 8/1, you're going to get the old rate, but that's because we've already submitted payment for the old rate. Change didn't happen until after I ran the report. So now when I run the next one, you'll get paid on the mid-month. Okay? Payment notifications. If you are an ACH, you get direct deposit. We don't send a payment breakdown to you in the mail any longer. The city, not just housing, the city does not send out your payment breakdowns if you're an ACH payment method. So you would take this link or you would write that down because that means we can email you your payment notifications. The day the payment is made, you will get your payment notification and you will get your breakdown on who we are paying you for and the month. If you are a live check, it comes attached to your live check. So just make sure you're paying attention to that. Some people get used to just tearing off the check and throwing everything else away. Well, who did I pay you for? It's in the trash now. So please make sure you know whether or not you have a live check or if you're getting direct deposit. On the other opposite, if you have an ACH, you see that your money hit in the morning, but you haven't got your email telling you what the breakdown is for, please allow that full day of payment because sometimes banks release payments before our emails have gone out telling you who we're paying you for. So just allow us that day for everything to come in. If you don't see it on the next business day, the next slide will have the OHA accounting email address. You can always email, and I will make sure that that gets out to you. And then owner updates. I take care of all of the owner updates. If your tax ID has changed, if your bank account information has changed, your email, your phone, any owner updates. It is important, as you can see, a lot of our stuff comes via mail. And so we want to make sure that we have the most updated information for you, for your inspections, for your payments, any other notifications. So you would email the OHA accounting, allow me 24 to 48 hours to respond, and then we'll get those all updated for you. Did I go too fast? Any questions? Yay.
Do we have any other questions just overall that we didn't answer? Oh, okay. We absolutely are. Yes, absolutely. We're here to help and assist our existing participants in the program. We are always looking for new landlords and property owners who want to help and assist us. It's always difficult in this market to find some good landlords and some good places for our folks to live in. So yes, contact us at section8@oceansideca.org if you're interested in participating, and we will get your information and updates. There are no further questions. Are y'all all, oh, okay.
I have a question. regarding if you're single housing and you're thinking of doing ADU on the property, would that affect the housing rental agreement or anything like that?
So you own the single family, you're renting that out for an HCV participant, but you want to build on to it and add another ADU? No, that has nothing. It won't have any. And we encourage folks to build more ADUs. It's a good form of housing and increases our housing stock. But there's no limitation and there's no interaction with our program. Yeah.
Thank you.
The only other thing I was gonna, oh.
In regards to if the tenant moves to a new property, how the rent has to remain the same and it can't change, not even by $1. I'm trying to understand what that is now.
Okay. So that's all part of every housing authority probably in the nation is right now struggling. We have very limited dollars. Trey has alluded to, this was an analogy he made. We have 1,400 checks. We don't necessarily have enough money in our bank account to pay for 1,400 checks. Maybe we can pay for 1,200 checks, and that's about all. And then they start bouncing. And so because of this issue of lack of resources, most agencies now have either put a pause on our Housing Choice Voucher program, and we have put a pause on our Housing Choice Voucher, meaning that people are welcome to be on our waiting list, but you're going to be waiting a long time. We haven't pulled from our waiting list since
January 24.
January 2024. And at this point in time, there's no expectation that we're going to pull because we just don't have enough federal resources to fund all those vouchers. So we're accepting waiting list people, but we are not pulling from that waiting list. We are not issuing any new vouchers. We have switched to a model of project-based vouchering, which means that we are providing vouchers to particular developments. Those have been in the works before all of the money situation came about. And so that's where a lot of these policies and the notices have come from, is that because we need to tighten our belt, HUD has given us very specific directions on what we can or cannot do. One was no new lease ups, no new vouchers. Two, it's look at where you're sending folks. Are you sending folks to high housing cost markets or higher cost areas? We shouldn't be doing that either. So it's one of these belt tightening measures that we're doing. And we're not the only ones. The city of Carlsbad's in the same situation, the county's in the same situation, and the housing are all in the same situation.
We get a tenant that's already in Section 8.
Mm-hmm.
But they're already clean. Is that what it means? Or what does it mean to us?
So in your situation, you're saying someone's moving into your community or? Okay, so this is, no, that's fine. So rent increases are allowable for existing tenants if they are rent reasonable. The key thing that we wanted to send out was, even though we turned off the faucet for, we're not taking in any incoming Section 8 applicants or participants. And our main goal is to continue to house those folks that are on the program. So those restrictions in place for tenants moving to another unit where their housing assistance payment is $1 over, that's really for them. So before a tenant comes to your community and rents, we'll sort of identify whether that voluntary move is allowed under our new restrictions that are in place. So that's pretty much it. A tenant can't move to another unit if their HAP is their housing assistance payment's $1 over what they currently have. Yeah.
Does that mean that they will be allowed to pay the 2,000 that they're already paying at the previous property?
Yeah, if it's a voluntary move, they're willing to move, and their HAP payment, of course, we get a new move-in packet. We calculate what their income, what the tenant portion and the housing assistance payment would be. Just to break it down, if their HAP payment is $2,200 in the new unit versus the $2,000, and it's a voluntary move, we would not allow it. They would have to stay in place.
Wouldn't even allow.
Oh, okay, okay. All right, thank you.
More of a tenant, it's more of tenant issues than it would.
So it doesn't apply to the new tenant, it applies to the transfer tenant, and they have to be authorized by you, not necessarily my new rent amount to them. Okay.
Right, the voluntary versus involuntary. There are several people that are able to move right now that are not considered involuntary. So they've gotten like a notice to leave from their current unit. Maybe they're selling the property or something. And so they're not restricted to those same $1 differences. They're going the old school way where we give them the MaxMet worksheet, and then that's what their budget is within each zip code of Oceanside. So you may have people that are still coming in that way, or you may have somebody that will deny at the front before you even do an inspection. We'll likely deny it once we get the RFTA and see the dollar amounts.
So I just put up our website. So if you go to www.oceansidehcv.com, it'll take you straight to the Section 8 website. You're going to go to landlords and tenants. You point out here, see this quick link right here, HCV forms and documents. That's where everything is at. You click on that link, takes you to forms and documents. You'll see right away there are some the more frequently used forms will be under tenant versus landlord property owner or planning documents. If you don't see it there, it might likely be in this file folder here, right here, if it's not here. So I know that there was someone who asked, how do I know who's my caseworker or housing specialist assigned? It isn't necessarily here, but if you clicked on, you're going to get a whole list of all the different forms and you might find it there. But we're trying to drive everyone to the website and have the most up-to-date information there so that you have it at your fingertips and you don't have to wait for an email response back from us or a call back. You can readily find it on the website. So with that, again, thank you for your participation today. Hopefully you found it informative. And again, I really appreciate the interactiveness of this forum and the ability to learn from each other. That's what this is all about, is building partnerships. It's the only way we're going to get anything done in life, whether it's HCV or just anything, is just the partnerships, leveraging resources, the communication. And again, I would suggest that if there are things that work really well at the Housing Commission, the County of San Diego, or anywhere else, please forward that to us. If you have some other thoughts and ideas, we welcome that. If we didn't get to your question today, or you have very specific circumstances, then contact us using the Section 8 housing email. That way we can kind of control where it is and send it to the right people to respond. So with that, that concludes today, and appreciate your time and your effort in being here.